Welcome, my ducklings. I am the loud little ducky. Today we are finishing the Gillespie versus Owens or Owens versus Gillespie in part 4. If there is other updates in this case or any other case, then we will continue to cover the continuance of them. But let's get started. So a little minor correction. In part 3 of the Gillespie series, I had stated that the August 9th hearing and August 17th hearing in 2022 went together. It was the August 11th and 17th hearings that were together for the abortion coercion hearing. The August 9th was a hearing in 2023 with the intentional infliction of emotional distress claim from Owens and the counterclaim for the same from Gillespie. So I just wanted to make sure we corrected that. And I will have the links to all 3 of those hearings on Schnitzel Ninja's channel, linked for you in the description box so you can take a look at those hearings yourself if you would like. This is the last court document that I have on this particular case that we have not covered. It was filed on February 15th, 2022 in Superior Court, State of Arizona, in and for the County of Maricopa in Owens v. Gillespie. This is Woodnick's filing, which is Gillespie's filing. Motion to dismiss / motion for judgment on pleadings for plaintiff's abortion coercion claim, and it was assigned to the Honorable Judge Bacchus. Defendant Gregory Gillespie, by and through undersigned counsel, hereby respectfully moves to dismiss the allegation of abortion coercion contained in plaintiff's complaint pursuant to 12b-6 and 12b-7, and as a motion for judgment on the pleadings pursuant to Rule 12c, Arizona Rules of Civil Procedure, ARCP. This court denied a prior motion to dismiss on December 14, 2021, for a failure by defendant to consult with plaintiffs pursuant to 12j, and to allege plaintiff's complaint did not contain facts warranting relief under any interpretation. The current motion differs significantly from the previous, as it is confined to a particular statute cited by the plaintiff in her complaint and contains allegations that the court must adjudicate pursuant to Arizona Rules of Civil Procedure 12b-6 and 7. Attached to this motion is a good faith consultation certificate as required by Rules 7.1h and 12j. As and for his motion, Mr. Gillespie states and alleges as follows. Now, we did go over, I did a whole video on the law in Arizona of abortion coercion because I want us to understand these things, and these are part of what were argued in this particular case on these claims of the abortion coercion. So the argument is plaintiff alleges 3 counts for relief in her complaint. 1, ARS 133601, which she voluntarily dismissed upon learning that Title 13 does not create civil cause of action. 2, ARS 362153, abortion conducted without informed consent. And 3, the tort of intentional infliction of emotional distress. Plaintiff's claims for relief under ARS 362153 fails because the statute does not create a cause of action for any defendant's conduct alleged in the complaint. Moreover, to the extent the statute creates a cause of action, such action may only be brought against a person who conducts an abortion without informed consent, which the statute defines precisely and at great length in a manner unrelated to any of defendant's alleged conduct. No such person is joined in this action, nor does plaintiff allege that any person other than herself performed or induced an abortion as defined in the statute. So the acts that caused the abortion are the acts of Owens herself, is what they are stating here. They don't know of any other person, like a doctor or anybody from Planned Parenthood and so forth, that performed this alleged act. But Owens performed the act that would have caused the abortion. Greg did not perform this act. 1. Plaintiff's complaint fails to state a claim for which relief can be granted. Abortion coercion claim, statutory language. Plaintiff alleges that the defendant has violated ARS 362153G. The subsection states in the first sentence, a person shall not intimidate or coerce in any way person to obtain an abortion. This provision does not contain any further explanation of what intimidate or coerce in any way means in this context. Nor does it state that a person who does these things is liable for damages. It does not on its face create a cause of action for damages against defendant. The remainder of subsection G goes on to state that a parent cannot coerce a minor to obtain an abortion, then prescribes certain remedies for a minor whose parents deny her financial support due to the minor's refusal to have an abortion performed. Again, nothing in subsection G or the statute defines intimidation or coercion, nor does any part of the statute express state of cause of action for intimidation or coercion. In matters of statutory interpretation, the court must read the entire statute and interpret each term within the context of its accompanying provisions. Footnote 1. They cite Georgia v. Gaynor-Fonte. It is a case out of Arizona from 2005. When a statute expressly lists things of a class, unlisted members or objects of the same class must be excluded absent language to the contrary, e.g., for example, including but not limited to, see footnote 2. Southwestern Iron and Steel Industrial Incorporated versus the state. This was a case in 1979 adopting the statutory principle of expressio unis est exclusio alteris. That I think is Latin, because that's, I think, what the law is kind of somewhat written in, was Latin. I could be wrong. Do not hold me to that. In 362153, there are several such lists. The statute lists information that a physician who is to perform an abortion must provide to the woman receiving the abortion orally and in person at least 24 hours before the procedure. We know Owens doesn't claim to go to these places at some point and then 24 hours return. She just walks in. Like she is a walk-in client. And they are like, we don't take walk-ins to do this. You have to come back after you've been given all the information in person and orally. And you got to sign some papers and stuff too later. And they're not even going to take your money until 24 hours later. 362153A1A through G, the statute lists additional information that must be given orally and in person at least 24 hours before the procedure by the physician or qualified professional to whom the responsibility has been delegated. At A2, A through H, the statute then lists other requirements for receiving and documenting the patient's informed consent, including information about drug mifepristone and the medical indications supporting an emergency procedure if applicable. B, C. Then the statute instructs the Department of Health Services to establish and maintain a website with an enumerated list of information to be kept and made available. D1. 8. Later, the statute identifies people who may file a civil action under the statute and the available relief for damages resulting from a violation of the statute, again expressly stating that the claim is based on failure to obtain informed consent before performing an abortion, at K 1 through 3 and L 1 through 3. The statute does not create a cause of action against a person who did not perform an abortion without informed consent. Greg did not perform the abortion with consent or without consent. He didn't perform it, period. So he's not the person, according to what this states. ARS 362153 does create a cause of action under subsection K, specifically for whom the father of an unborn child or a maternal grandmother or grandparent, parent to recover against a physician who performed an abortion without informed consent, as defined by subsection A detailed above. Subsection K provides K. In addition to other remedies available under the common or statutory law of this state, any of the following may file a civil action to obtain appropriate relief for a violation of this section. 1. A woman on whom an abortion has been performed without her informed consent as required by this section. So, informed consent has to be done. And you know who can sign off to get abortion pills for informed consent and so forth? The person that gets them. But there should be a paper trail if she actually did this. But we don't have that paper trail. We have nothing from the doctors who she got these pills from that she didn't take right, or took one right, didn't take the other one right, and then had to start over a second time and all that nonsense. 2 other statutes in Title 36, Chapter 20 impose other requirements relating to informed consent, all of which are acts and conditions required of the provider. See ARS 362156 and 362158. In fact, every statute in the chapter describes requirements for a medical provider, not private citizens. So in this abortion coercion, in the statutes, a lot of it's talking about doctors not being able to just do things without informed consent, without all these things. It's not talking about a private citizen. Like, they can't, it's not saying, oh, you know, if this person does this or says these things, then this is what it is. It doesn't talk about that. No, it would be way different if somebody had drugged her and cut her up and she didn't sign anything, and but she was by herself when she went to do this. I don't know if her mother tagged along or if her mother says she's tagged along. But Greg was not there. He didn't force her. He didn't threaten her. He didn't intimidate her. Nor did he perform any threatening or violent acts on her. No threats or violent acts. And the statute talks about medical providers, not private citizens. Statutory interpretation. The plain language of the statute limits the cause of action to the conduct the statute requires of medical providers conducting abortion procedures. The only express claims it creates are for the women, the father, or maternal grandparents to sue the provider who performed an abortion without informed consent. Every cognizable claim under the operative sections of the statute require that an abortion was conducted without informed consent, and the duty to obtain and keep records of the informed consent rests squarely on the physician. Again, we're talking about medical providers, not private citizens like Gillespie. The statute cannot be reasonably read in any way except that relief must be sought from the physician who performed the abortion. Because of the cause of action arises from an abortion conducted without informed consent, and the statute's definition of informed consent refers entirely to acts the provider must undertake. There is simply no cause against a private citizen unless they performed an abortion procedure, an act that is prohibited by ARS 362155. So Greg did not perform an abortion procedure on Owens. We know that. So he, so far, according to his lawyers and the statutes, if they're being interpreted correctly, let me know what you think. He doesn't fall under any of this. He hasn't broken any of those laws because they don't pertain to him. The remedy, if there is one, cannot come from defendant because he did not perform or induce an abortion without informed consent. He cannot do so, nor does the complaint allege that he did. Moreover, he has no duty to engage in any of the acts required by the statute or any other statute in Title 36, Chapter 20. The complaint asserts that the plaintiff obtained the abortion pills. Owens obtained the abortion pills. Complaint at 28, paragraph 16, administered the first pill, not in the defendant's presence, paragraph 18. It's not in Greg Gillespie's presence. Administered the second pill a day later, outside of the defendant's presence, paragraph 21. Once again, Gillespie was not there a day later for that second pill. Administered the second pill again 2 days after that, outside Gillespie's presence. Complaint at 29, paragraph 24. Administered the first pill again 4 days after that, outside of the defendant's presence. Complaint at 30, paragraph 36. And finally, administered the second pill for a third time, the only relevant act in defendant's presence, another day after that, paragraph 40. So she took the first pill, 2 second pills, nope. So we got a second pill, a second pill, a second pill, a first pill. So after like 6 pills, because she would have had to take the first, then the second, then she took the second again, makes it 3, first pill again. So 5 or 6 pills, yeah. So it wasn't until the 5th one that she took in the presence of the defendant, Gillespie. Plaintiff alleges in the complaint that she undertook at least 5 affirmative acts inducing an abortion outside of the defendant's presence and another affirmative act in his presence, but does not allege that the defendant performed or induced an abortion. So she does not claim that Gillespie shoved this pill down her throat, held her down, made her take it, put it in a drink without her knowing. None of that. She took it in front of him herself. Her act caused these things, not Gillespie's acts. None of the conduct alleged against defendant constitutes performing or inducing an abortion, nor does the complaint allege defendant had a duty or failed to comply with the statute-informed consent requirements. Therefore, even accepting all material facts pled by plaintiff as true for purposes of adjudicating the pleadings, she would not be entitled to relief under any interpretation of the facts susceptible of proof. And they cite FidSec Life Insurance Company versus State Department of Inc. That is an Arizona case from 1998. This is because the statute simply does not contemplate the relief she is requesting. So she wants this relief that isn't out there for her, which it's not the first time she's tried to get some relief monetary wise for things that don't exist for her. Intimidation or coercion. Assuming, arguendo, that the statute creates an independent cause of action in the absence of a defendant performing an abortion without informed consent, the only remotely cognizable claim is that a person's intimidation or coercion forced someone to perform or induce an abortion. As discussed in the previous section, plaintiff undertook all of the affirmative acts that she alleged resulted in the termination of her pregnancy and did so almost entirely outside a defendant's presence. So Owens' acts that allegedly caused the termination of her pregnancy were done almost entirely outside of Gillespie's presence. He was not there. Her complaint does not state that defendant Gillespie coerced her, but rather that she terminated the pregnancy for the sake of a relationship with the defendant Gillespie. This is what she did with Clayton as well. Sign my dating contract. Be in a relationship with me. And then I'll get rid of the babies. As I've said in the Clayton case, Owens, and yes, I am going to say babies don't exist, but even if they did, Owens does not give two cruds about those babies, babies, because she is willing to toss them aside, get rid of them for a relationship, even if it's for a week or two. Can you imagine being like, you know what? Just for a week or 2 weeks of dating, I'll get rid of these babies. We'll just get rid of them. Just for 2 weeks of fake love. Who does that? That is not unconditional mother love. And then she wants to talk about, oh, I'm scared for myself and my unborn babies. You don't care about these fictitious babies from any of these 4 men in any of the 10 years where babies have pretended to be in your existence. Have you cared about any of them? What would you do if you actually ended up pregnant? Would you do the same thing? Because I don't think you would. I don't think you'd toss real babies aside like this. But because there is no babies, you will just throw them away like they don't exist, because they don't. Complaint at 30, paragraph 42 and 46. Therefore, taking the facts alleged in complaint as true, plaintiff herself asserts that she chose to terminate the pregnancy based on the belief that she could continue to have a relationship with the defendant. In the light most favorable to her, it would be surmised that the plaintiff, Owens, means to claim that she relied on promises from defendant Gillespie. Accordingly, the question is whether promises qualify as intimidation or coercion in this context. Title 36 does not define intimidation or coercion, but the terms are used in other statutes with specific meanings. ARS 13-1202, a criminal statute, defines intimidation as intimidating by words or conduct to injure someone, to cause serious damage to their property, to cause serious public inconvenience, such as evacuation of a building, or to injure damaged property or of another person, to assist in a criminal street gang, syndicated, or racketeering enterprise. ARS 13-1307, the criminal sex trafficking statute defines coercion as threatening to abuse the law, making a passport or the government identification inaccessible to its owner, extortion, causing or threatening financial harm, or facilitating or controlling a person's access to a controlled substance. The complaint does not allege that the defendant did any of these things. Defendant cannot find any legal support for plaintiff's position that offering to remain in a relationship with somebody if they terminate their pregnancy is intimidating or coercive. The acts she alleged: the defendant promised he would work toward a marriage and eventually have a child with her, complaint at 28, paragraph 13, attend an event with her, example at 29, paragraph 29, wanted to start a family with her, wanted to meet her father, support her after this, and begin their relationship, paragraph 32, which we do not have those documents for those paragraphs to read. If they ever come out, we will read them. Are not even remotely the kind of words or conduct that Arizona law elsewhere defines as intimidation or coercion. The only acts in the complaint that might come close are the alleged threats to go public with the plaintiff's abortion to damage her reputation, paragraph 44. But that is alleged to have occurred after plaintiff's actions to abort the pregnancy, and is therefore temporarily excluded. Again, assuming all the facts alleged in the complaint are true, there is no conceivable claim for which relief can be granted. So if every single thing that Owens said was true, I know, that's pretty funny. I couldn't even say that with a straight face. If everything Owens said was truthful, which would be a first time in her life, it still would not meet the standards. And it definitely doesn't meet the standards if everything she says is false. But like we've discussed before, and this document is basically it's a longer version of what Gillespie's attorney argued at the hearing about abortion coercion. He threatened to go public with the abortion if she hadn't done it or whatever. If you haven't taken the pills or if you haven't had the abortion, I'm going to go public with this and damage your reputation. Well, she had already taken a couple of pills. And she lied about taking pills, too. So, when she's already performed an act to cause an abortion, he can't coerce her into something she's already done. Granted, he thought all this was fishy anyways. So, men don't do this. If somebody is really pregnant with your babies, do not say a bunch of this stuff. All right, going into section 2. Plaintiff failed to join a necessary party to recover for an abortion without informed consent. Laura Owens had to give informed consent to go through with this. To get the pills, she had to give informed consent. Whether she filled them or she was just given them. If she was given a prescription and went and filled them, she gave her consent. When she swallowed them, she gave her consent. When she took them from the doctor, if there was a doctor, and there is pills, who knows, she could have just taken a Tylenol or an ibuprofen or some kind of vitamin in front of him and be like, yep, this is the second abortion pill. This is the third time I'm taking it. We don't know what that pill was. Because plaintiff's ARS 362153 claim can only be remedied through a cause of action against the physician who performed the abortion without her informed consent, or is at least predicated on the requirement that an abortion without informed consent actually happened. Plaintiff has failed to join a necessary party. ARS 362153 imposes an affirmative duty on the physician performing the abortion to obtain the qualifying individual's informed consent. We don't know who the physician is in this. Plaintiff hasn't attached them or jointly sued them. There's no records of this. We have no knowledge of anything. We just have Owens' word. And you know what that is. Not a thing. Nothing she says is anything. Under Rule 19A(1)(a), the physician who performed the abortion on plaintiff must be joined because the court cannot accord complete relief or any relief for that matter among the existing parties. Even if defendant's actions did create an actionable claim for an abortion without informed consent, the complaint must necessarily be against both the defendant and whoever performed or induced the abortion. The provider who conducted the procedure or, as here, authorized the plaintiff's use of abortion-inducing medication has the duty to receive a document of informed consent. Yeah, where's the document? Did you sign something, Owens? Because I don't think you did. If plaintiff acquired the medications which she administered 6 times without consulting a medical provider, then there is no intervening party who could have received informed consent. So if she got a hold of these abortion pills and it wasn't through a medical provider or a doctor, then there's no party to have received informed consent, and she did that all on her own. Greg didn't go pick up these pills, wherever these pills came from. She did. Paradoxically, the only person who could have ensured informed consent would have been the plaintiff Owens herself. Because that would clearly not be a cognizable claim, the complainant would have to be dismissed outright. In the alternative, if plaintiff did not receive authorization from a physician and now alleges the abortion was performed or induced without her informed consent, then relief can only be afforded if that physician is joined as a party. After all, their intervening breach of duty proximately caused the alleged harm. The physician, if there is one, must be at least partially liable under the statute and share the attribution of fault or indemnify defendant. Plaintiff has failed to join the physician as a necessary party to the litigation, making it impossible for this court to adjudicate the ARS 362153 claim. Section 3. ARS 362153 is unconstitutional. Okay. The statute here cited in support of plaintiff's complaint is unconstitutional as applied to defendant. If the statute creates the cause of action plaintiff allege, then it acts as an impermissible content-based prior restraint on speech in violation of the First Amendment. So basically, if something that Gillespie said in expressing his opinions and feelings and has the right to say, because, freedom of speech, no law can come in and say that we do not have the right to speak out. You can't go telling lies and falsity, but if you're telling the truth and you're just speaking in opinions and not full-fledged absolutes when there is no absolutes, these rules would violate Gillespie's First Amendment right. And of course, that is given to us in the United States Constitution. Furthermore, the statute violates the Due Process Clause of the 14th Amendment because it is impossible to determine what acts a person must not do to avoid liability. A. ARS 362153G violates the First Amendment. A. ARS 362153G acts as a prior restraint on free speech. The First Amendment guarantees citizens the right of freedom of speech, and through the 14th Amendment, this right is protected against state action. See footnote 3, Saya versus People of the State of New York, and that is from 1948. A statute acts as a prior restraint on freedom of speech when it suppresses the prized freedom which the First Amendment sought to protect against abridgment. See footnote Carroll v. President and Commoners of Princess Anne in 1968. The Supreme Court of the United States was held there is heavy presumption against constitutionality of prior restraints on expression. 5. Organization for Better, Austin versus Keefe, that was in 1971, and it quoted the Carroll v. President, Commoners of Princess Anne. Reasonable restrictions on time and place or manner of protected speech are not prior restraints. 16B CJS, Constitutional Law, revised or is stated in 2022. Here, ARS 362153G seeks to prevent individuals from expressing their opinions or belief about abortion with no regard to time, place, or manner. The relevant sentence of the statute, which prohibits a person from certain speech at any time in front of any person, acts as a prior restraint on speech that the Constitution would otherwise protect. Discussing abortion law in front of a pregnant woman could be construed to be prohibited under the statute. Discussing abortion procedures or risks of full-term pregnancy at a medical symposium could be prohibited. Expressing one's personal opinion about the morality of abortion in private conversations, e.g., I believe that bearing an unwanted child who the parents cannot support is unethical, could be construed to violate the statute. All that would be required is the speech intimidates or coerces a person in any way to receive an abortion. Because those terms are so impenetrably broad, discussed further below, the only guaranteed way to avoid potentially liability is to remain silent. That is the textbook definition of prior restraint and plainly violates the Constitution. So they cannot say that because Gillespie gave his opinion and his thoughts about the entire thing and about an abortion, they can't hold that against him because it messes with his First Amendment and 14th Amendment rights. A person's right to express their views without fear of liability is precisely the freedom the First Amendment is designed to protect. U.S. versus Stevens in 2010. Does not extend only to the categories of speech that survive an ad hoc balancing of relative social cost and benefits. See also Virginia versus Black of 2003. The hallmark of protection of speech is allowed free trade in ideas, even ideas that overwhelming majority of people might find distasteful or discomforting. Quoting Abrams v. United States, 1919. Holmes J. Dissenting. So even if you don't like the person's speech, you can't tell them that they can't say those things. They have the right to say it. The Supreme Court held this right can only be restricted in few limited circumstances, such as when the words themselves are inherently likely to provoke a violent reaction. Cohen v. California of 1971. Two individual parties privately discussing how to proceed with a pregnancy cannot be prohibited in the manner the statute purports. You're having a private conversation. You're in a text. You're not out there doing a lot of extra stuff. You were having a conversation with a woman that is supposedly pregnant with your child or children and telling them that you don't want them to have the baby, you want them to get an abortion, and then they want to keep playing with you and you don't like that they're playing with you. You have the right to say what you want to say without it being considered intimidation and coercion in this context. B. ARS 362153G is void for vagueness. See footnote 9. While the doctrine of vagueness is more commonly applied to criminal or penal statutes, it is also applicable when the statute affects the First Amendment. Grayned versus the City of Rockford from 1972, where a vague statute about upon sensitive areas of basic First Amendment freedom, it operates to inhibit the exercise of those freedoms. A statute is void for vagueness under the First and Fifth Amendments when the person of ordinary intelligence, so you don't even got to be a really smart person, you could be a dumb person, if you have some intelligence, is not given a reasonable opportunity to know what is prohibited and where application of the law will lead to arbitrary and discriminatory enforcement. Footnote 10, Grayned versus City of Rockford, 1972. See also Conley versus General Construction Company of 1926. Holding a criminal statute is vague when men of common intelligence must guess at its meaning. So you cannot, a reasonable person has to be able to understand. You can't make things so smart that just an ordinary person doesn't understand. And it can't be so vague as to where they don't understand what it means. Here, the statute states a person shall not intimidate or coerce in any way any person to obtain an abortion. Emphasis added. Footnote 11, ARS 362153G, which is what we've been going over. The statute does not specifically what it means to intimidate or coerce, or what conduct constitutes any way of so doing. Although the statute ostensibly proposes is noble, no one should ever be intimidated or coerced into any significant act against their wishes. Its mandate is impossible to elucidate. I don't even know that word. That's a fancy word, Mr. Woodnick. Defendant's counsel does not routinely ask rhetorical questions and motions, but they seem warranted here. Does expressing a viewpoint about abortion without knowledge of being overheard count as any way of intimidating or coercing any person? Does it matter whether the person speaking has a reason to know any person might find their opinion or actions intimidating or coercive? Would handing out pamphlets with information about possible harm of teenage pregnancy constitute intimidation? Does any person include someone who is not yet pregnant, or the speaker does not know is pregnant, or someone who cannot become pregnant at all? Does an actual completed abortion procedure need to take place, or is the mere intimidating or coercive influence sufficiently actionable? What if the intimidation or coercion pertains to a medically necessary procedure, such as a husband pleading with his wife to terminate the pregnancy that will likely kill her if it's carried to full term? An emotional plea between individuals in their private sphere surely cannot be what the statute hopes to enjoin. Can a person intimidate or coerce themselves into obtaining an abortion? The statute certainly suggests it is possible. With its amazing broad sweep, it doesn't say a person shall not intimidate any other person. These questions do not have answers, and that is exactly why the statute must fail. If there is no way for a person to discern what speech or conduct is permitted, us ordinarily intelligent people, The statute is unconstitutionally vague. A statute like this that has interpretations with no discernible standard of conduct is void for vagueness under the First Amendment. He then again quotes Conley v. General Construction, 1926. The legislative history is similarly ambiguous under a section entitled Miscellaneous. The statute sponsor states the statute stipulates that a person, including a parent or guardian of a minor, shall not coerce in any way a person to obtain an abortion. Arizona House Bill Summary of 2009. The legislative sessions following the statute proposal, devoid of any discussion over the meaning of the provisions and the wording of subsection G, remains the same in every iteration of the bill. The term abortion coercion has never been used by Arizona courts to defendant's knowledge, nor in the Ninth Circuit or the Supreme Court of the United States. Absent an ability to discern the meaning of the statute, individuals are not given a reasonable opportunity to conform their conduct to abide by the statute, and its enforcement is likely to be arbitrary and discriminatory. Gaynard Gray, Ned versus City of Rockford, 1972. ARS 362153G contravenes the rights of individuals to exercise their right to free speech without restrictions or any semblance of clarity as to what the conduct of the statute is seeking to deter. ARS 362153G is void for vagueness and unconstitutional. Yeah, if we don't know what the exact law is and what the statute grants and doesn't grant, what do we have permission to say and do and what do we not, that could get us in trouble with the law, how are we supposed to abide by a law that we don't know what it is? From somebody of ordinary intelligence, just a normal, plain Jane, common sense person. That would be unconstitutional, as he states here. C. ARS 362153G is overbroad under the First Amendment. A statute is overbroad when a substantive number of its applications are unconstitutional, judged in relation to the statute's plain legitimately sweep. Baldwin in 1995, quoting State v. Jones of 93, an overbroad statute is one designed to burden or punish activities which are not constitutionally protected, but includes within its scope activities which are protected by the First Amendment. ARS 362153G does not provide any clarity as to what conduct would constitute a violation, nor does the statute define what constitutes intimidate or coerce. Therefore, it must be presumed the statute applies to any speech related to abortion if the receiver subjectively believes it to be intimidating or coercive. Under this reading, any time a person referenced speaks about, acknowledges, etc., abortion, the statute may be triggered. It may be assumed, for the sake of the analysis, that the plainly legitimate sweep of the statute would be physical or violent coercion to obtain an abortion, terminate your pregnancy or else, but the broad language surely encapsulates speech or behavior that is not criminal. As such, there are a wide range of conversations that would be considered violative of the statute that are protected by the First Amendment. In particular, the statute could prohibit communication that occurs within the zone of privacy protected by the 14th Amendment. Griswold v. Connecticut of 1965. The First Amendment has su nombre, where privacy is protected from government intrusion. Is not criminal. Okay, zone of privacy protected by the 14th Amendment. The Supreme Court held that there is protected zone that encompasses the conduct of married and unmarried persons, particularly with the decisions regarding family planning, as the decision of whether to bear or beget a child is a fundamental right. Footnote 17. Holding married couples have a right to privacy. Eisenstadt versus Baird of 1972. If the right of privacy means anything, it is the right of an individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. As such, the state action seeking to intervene in the right is subject to strict scrutiny. Griswold v. Connecticut, White J. concurring, a statute survives strict scrutiny only when it is narrowly tailored to further a compelling government interest. Given the overbroad of the statute at issue, it can be presumed it would fail to survive strict scrutiny. More generally, suppose an individual electronically posts a statement indicating they are pro-choice on social media, and someone who greatly respects their opinion reads the statement and feels pressure to abort their pregnancy, unbeknownst to the speaker. Under the statute, any person who comes across the statement and finds it to be intimidating or coercive could assert that they are a victim of abortion coercion. Which, yes, he's going to the extreme, but he's making a valid point that this would be stupid. Like, this is like so far-fetched, but if that's what you're going to say can happen, then this can happen, and that's ridiculous. Without the ability to discern the meaning of the statute and exclude legitimate permissibility conduct from its prohibition. I cannot read, of course, y'all know this, I cannot read. The statute is void for overbreadth and unconstitutional. Wherefore, defendant hereby respectfully requests the following. A, that this court dismiss plaintiff's complaint with regards to the abortion coercion claim with prejudice, pursuant to 12b-6 or 12b-7. In the alternative, that this court dismiss plaintiff's complaint on the grounds that ARS 362153G is unconstitutional. B, that this court award defendant his attorney's fees and costs pursuant to ARS 12341 and 12349, and C, that this court grants such other and further relief as deemed appropriately. Respectfully submitted the 15th day of February 2022, and it was sent to the correct people. The under oath verification, everything's true and correct type thing was signed. So that one is not like, it doesn't have a whole lot of juicy detail. It has some. But, cases and, law is not always just fun and juicy and everything like that. There are parts that are just what they are. They're just kind of bland. But those bland parts are important to understand our rights and to back us up when we haven't done something wrong. And if we have, they're there to be like, you see right here in black and white, it says, thou shalt not do that. Okay, that might be in the Bible too. But it's interesting because he covered, abortion coercion laws and the physicians and stuff like that. We don't have a physician in this case. Then he goes into talking about the First Amendment, freedom of speech, protected privacy, things like that. Because what we say in a private conversation, can it end up coming out in court? Absolutely. But things that you say, you have the right to say them. Doesn't mean it's going to make you look good. As we've seen in the Karen Reed trial with Proctor's lovely text messages. They don't make you look good. But he had a First Amendment right to say them. He looks like a garbage human for doing it. But he's allowed to say it. He just shouldn't. Just because you can, don't mean you should. So that is that motion. That is basically what was argued in the abortion coercion hearings, which again were on the 11th and the 17th of 2022. Linked in description box. So now, with fake ultrasounds, dating requests, and hacking excuses, we are entering June 29th of 2023 to June 10th, 2024. So almost a year from June 29th, 2023. And part of this has to do with the Clayton Echard case. But she's still got Gillespie's name in her mouth. And Gillespie's probably thinking, keep your name out of your dirty, filthy mouth. Keep my name out of it. But let's go to the original. On 6/29/2023, Echard sent Owens an email requesting she give consent for him to speak to the provider about her visit, in which he indicates it's the last request. He also indicates he is not interested in dating. July 25th, 2023, Echard tells Owens he will not meet up to explore things with her. He's in receipt of what he believes to be fake ultrasounds at this point. Owens has begun making excuses for waiting for paternity tests until February. We know Owens blames excuses on Clayton, had the excuses, not her. But here's where we kind of get into the Greg Gillespie of it all that pertains to the Owens v. Gillespie. Owens later claims that this ultrasound was sent by a different victim who hacked her account and I guess sent a fake picture and questions about meeting up with him. And this different victim that Owens says hacked her account and sent this email and the videos and stuff like that, she says it was Gillespie that hacked her account. And then we go on to say, not sure what the plan was if Echard did agree to meet up with the hacker after the fake ultrasound, which if Clayton agreed to meet up with the person who hacked Owens' account and sent Clayton this message, then he would have met up with Gillespie. Like, they would have had a date with each other. And that didn't happen. There were no dates with Echard and Owens at this point either. So Clayton did not meet up with Owens or Gillespie, who Owens says hacked her account and sent all this. This is the same claim she made about Woodnick's firm hacking a California firm to pretend to be Owens, also known as Jane Doe, in past litigation. She also made the same claims in 2014 with another victim. So, repeated hacking claims. Okay, we'll skip that for a minute. So in 2014, she was using the hacking thing. She's used the hacking in all of these instances. Almost every case. I don't know if she used it in Maraschini, but she has in Clayton's and Gillespie's and apparently Matt's. Same playbook. And then even if she just left it there and was not going to continue to state these things and lie about someone hacking her account or saying that Greg hacked her account, Owens gets on the stand in Clayton Echard's trial on June 10th, 2024, just this past Monday, and states that she did not send that email from her email address with the GIF signature video thing with all the best and check out my TED Talk and my chicken soup for the soul and blah 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 blah. Like, it's a moving picture, which Clayton took a video of. That was all the same on there. And the things you have to do to hack, like, And she refused to send her laptop to be forensically analyzed, or her phone or something, because, well, then it would have confirmed that there was no hacking. So she repeated these claims and said, well, Gillespie, I suspect hacked into my account and did all this because he's been known to hack my account before, and I have heard he's hacked other people's accounts. So Gillespie is just a hacker. So Owens is still spinning this lie, and there is no proof whatsoever from the day they went on their first date till June 10th, 2024, that any hacking by Gillespie has been done. But Owens has to blame somebody but herself. Nothing can be her fault. That is where we are ending our Gillespie series for now. Right now, that's all that I have about this. And so I want to know what you guys think. Do you think that Gillespie could have done it? Is an aggressive person and did other things because he apparently had a restraining order on somebody else, and then Owens sought one. I think I figured out why Gillespie's protective order, he didn't have to be arrested like Maraschini, because Maraschini's was like activated for like an extended length of time, whereas Gillespie's was only a year. So I believe by the time that this trial happened, Gillespie was no longer under this restraining order or protective order. She did not get Gillespie's extended, as far as I know. That may be why she didn't have both guys arrested. But whether I know what to believe on Gillespie's past or certain things, I am pretty certain about the pregnancy part of things. And that's basically what we're here to judge, is the pregnancy stuff. Not the entire relationship, not his past, not anything else. We are basically just covering the claims of pregnancies and stuff that Owens has accused these men of doing, and looking at whether there is reason to believe it or not. Owens has huge credibility issues in the fact that this has been going on for 10 years, and there's 4 victims who have similar stories. It makes it really hard to believe that all 4 of these incidents could have happened almost identically. I'm not saying that somebody could not experience certain things 4 times, but not the exact same way, with the same exact amount of babies, and, without evidence. And when you don't have anything to back up a single pregnancy in 10 years with any amount of actual proof, none. What do you do with, you can't do anything with it. You have to toss it out. I can't consider anything she says because I don't believe her on a lot of it. Our quote of the day is, if it's not right, don't do it. If it's not true, don't say it. Simple. Indeed, that is. Speak the truth. Don't be out there lying. Do the right thing. Sometimes we don't, but try to correct it if you do the wrong thing and make it right. We're not perfect, but if we strive to be honest and truthful humans and individuals that want to act right and be law-abiding and good humans, then even when we mess up, or state something that might have been wrong, as I did at the beginning of this video, I correct it so that it is true, so that I am doing the right thing and not just saying things to say things. Please like this video, give it a big thumbs up, comment below, subscribe. You can turn those notification bells on if you want to know when I am dropping new videos. This might be it for the most part for anything related to Owens until we get the ruling from the Clayton Echard case. So we will be covering new people and new things. Some we can connect back to this case. Some will be way far from this particular kind of stuff, but we are always seeking truth, making sure that people are doing what's right, and trying to bring justice. Bye, y'all.